All right. For the appeal of the state of Kansas is now in session. The Honorable David Bruns presiding.
Please be seated. Well, good morning and welcome to our May docket here at the Kansas Judicial Center. It's my pleasure to be serving with two illustrious justices today. And I have on my right, your left, the Honorable Stephen Hill, who, as you may know, is the longest serving judge in the state of Kansas. We will not say anything about his age, but he is the longest serving judge in the state of Kansas. He's been on our court since, I believe, 2003. Is that accurate? Mm-hmm. And before that, he was a district judge in Miami County in that beautiful courthouse in Paola. And then on my left, your right, the Honorable Mary Christopher, who is even though we won't talk about ages, she's a senior judge on our court. I don't understand how that could be, since she was once one of my law students in a class I taught at Washburn Law School. But Judge Christopher for many years was a judge in the Shawnee County District Court, and prior to that was in private practice here in Topeka, and did some paralegal work as well, if I remember correctly. And for those who don't know, as Courtney said, I'm David Bruns, and I joined this court in 2011, I believe it was. And before that, I was a Shawnee County District Court judge and was in private practice here in Topeka prior to that. This morning, we have 3 cases on the docket. Each of the cases, the parties will have 15 minutes per side to present their arguments. I would ask that at the beginning of the appellant's argument that they let me know whether they want to reserve any time for rebuttal, and certainly can do that. As you know, and I like to say in honor of the Honorable Joseph Perrin, one of our former colleagues, we give you that time. You don't need to use it all unless you really want to. We have read your briefs. We've read pre-hearing memos prepared by our research attorneys. So we're pretty familiar with the facts. So usually you can just get into the argument. However you want to make your argument is certainly up to you. With that, we will go ahead and call the first case, which is State of Kansas versus McCulley. You'd state your appearances, please.
Brian Brown, arguing for Mr. McCulley, who is here with us, out in Orange, out on bond, thanks to Judge Austin.
And would you like to reserve any time for?
Yes, sir. I'd like to reserve 7 minutes.
7 minutes. You're done getting my math messed up here. So that'd be 8 and 7, right?
That's how I had it.
Okay. Well, that's why I didn't go to medical school.
Good morning. May it please the court. The state appears by Deputy District Attorney Joe Woodson.
Okay. Thank you. And with that, Mr. Brown, whenever you are ready, you may proceed. And I do have my cell phone out. It is not to check scores or anything. It's
okay
as a stopwatch.
Excellent, because I'm afraid mine's going to go black on me.
I might have to turn this one back on a couple of times as we do that.
Yeah. Okay. Well, Your Honor, Judge Hill, thank you for your service to the state of Kansas. Judge Christopher, I cannot believe you're a senior judge. Bruns, senior judge, evidently. I'm here to represent Jeremy, and I'd like to give you, I know the facts, maybe you know them, I'm glad you know them, but I'm going to give you the view from 75,000 feet as I see it. Jeremy was induced to waive his constitutional right to a jury trial upon representations from the state and his appointed counsel, who were both misled by a document wrongly filed to the docket by the Shawnee County Court. So I believe it's a triplicate error. The court filed the wrong document or wrote something on the document that was not deceptive, but incorrect. The prosecutor ran with it. Appointed counsel ran with it. No one stopped to say, could this document be wrong? And the document, it was wrong. The error caused both the court-appointed counsel and the prosecutor to believe and to negotiate and to inform Jeremy that his criminal history score was going to be a C, which is, of course, presumptive probation. Things went swimmingly at the plea bargain stage. The state insisted on a felony under the allegation that Jeremy had brandished an actual gun. Questions about that, I put the transcript in the record as to what exactly the facts are below, but Jeremy did make the deal. And the deal was for probation. I mean, you know, a defendant without legal education doesn't really slice the onions all that thin. He wanted probation, and that was what was important to him. Both the state and Jeremy's former counsel testified that probation was the assumption during all the negotiations, that probation was openly agreed upon, and that probation made sense. As a matter of fact, so much sense that at the end of the plea bargain, the prosecutor agreed that Jeremy could go free. He could go free that day. Yeah, we let him out on bond, because we all know at sentencing it's going to be probation. Well, then the PSI came back, and well, Jeremy had a B because of an inadvertent misunderstanding of what the document in the record was really saying. The document in the record was one case back, and it purported to be this case. So we missed a misdemeanor, and misdemeanors stack. And I know the prosecutor's going to argue with Jeremy should have known that, but the average layman doesn't understand stacking. And what happened in the last time you met before, and they were just treated like misdemeanors. Now you go before and they're treated like felonies. We've just shifted gears. And that gear shift is what brought us here. Was it a series of black swan events? Harsh fate in action? I think so. But it gets worse for Jeremy. His appointed counsel did not have his telephone number, and now he was no longer in jail. So she could not get a hold of him. She was not able to tell Jeremy until minutes before his sentencing. Look, something came back in the PSI. I can't fully explain it to you. We don't have much time, but you're facing jail. And he went before the judge, and the judge pronounced a 27-month sentence. And then the judge looked at Jeremy and said, "You weren't prepared for this. I can see." No, he wasn't. It was hard to allocate when he was in complete shock.
Remind me of this. Did Judge Osman take the plea and also do the sentencing?
Yes, sir. He did. His Honor had little discretion in the matter. Jeremy's criminal history after the misdemeanors were stacked put him at 11 to 34 months of incarceration. He did deny the downward departure. There wasn't much to it, just basically a motion for downward departure, not much argument. And so 27 months was what Jeremy walked away from. He would later testify in the
Did you
transcript.
ask for a dispositional departure?
He did. I believe they did durational and dispositional, although it was very vague. I was not below it. It was just a one sentence.
Did the court give any reason why?
Said,
Was all of this informed about the mistake? So a dispositional departure wasn't entertained, or did the court just reject it out of hand?
the court said that there was not compelling argument made to the court as to how a departure could be done. It was all done at sentencing. There wasn't an independent hearing. One of my concerns, and I understand, I do little of this. I'm not overseeing a cultural collapse. So I know that what goes on in the courthouse is an amazing flow of information, flow of cases, overburdened, and plea bargain works to keep that all going. But appointed counsel should have moved for continuance. And I believe that was one of the faults of appointed counsel here. Should have said, look, I'm sorry, everything has changed. You're not looking at presumptive probation, you're looking at presumptive prison. Let's ask the court for some time and fall back and see what your options are. Because as we all know, pre-sentence, he faced much less of an uphill battle than he does post-sentence to get that plea bargain called. Well, that was not given to him. So was this failure to move for continuance? Was this failure of the whole legal community of Jeremy, I think? Was this failure to follow through yet another black swan event and yet more harsh fate in action? It seems that way. His court-appointed attorney then said, look, you got to find another attorney. I can't represent you anymore, because she understood the conflicts were there. Within 14 days of sentencing, Jeremy's new counsel filed a motion to withdraw the plea bargain due to mutual mistake. The state opposed. District court took it under advisement. We had a full hearing on that with testimony of the prosecutor who did the plea, with testimony of the appointed counsel.
Did the state, there's something that was unclear to me. Did the state argue that there was no mutual mistake? I mean, I understand that they argued that he signed, that he realized the judge is in charge of sentencing. It could be higher than what, but did they at least agree there was a mutual mistake?
Now, if you'll look through my reply brief, I think, or certainly the brief in chief I set up forth, and I can give you in rebuttal those paragraphs. it came down to, it's a personal thing. One prosecutor said, I should have done this. I should have included the probation. I usually do, but it wasn't my case. I was called in and my name wasn't on it, so I didn't put a lot of time into it. No, that's.
Some other dude did it in the prosecutor's office.
Yeah, and then.
So, well, the reason why I asked that is because the prosecutor on the record said that it was inadvertently left out. So it seems like at the very least, they should have admitted that it was agreed it was a mutual mistake. Now, what the ramifications of that to a judge is a little different because of course, the judge can impose whatever guideline sentence they desire, but that's why I wondered if they at least admitted that there was a mutual mistake, because when they come in and say, prosecutor, quote, we probably should have, what we negotiated was anticipating probation, and I believe the written document inadvertently left that out. That seems like an admission of a mistake, but.
Yeah, I rather thought that, and I didn't think this case would end up here with that admission. I was surprised. But we're told by the state that that was not really that important of a criterion, that, you know, it's not that important of a term to my client.
So part of it is because we're after sentencing as opposed to prior to sentencing on the standard. And I suppose the other option is 1507 after this, depending where this goes. Okay. And you are at your 8 minutes, as your phone's evidently telling you, so you can either take a little more now and just reserve the rest, or just wrap up here and then have your 7 minutes.
You know, I'm at the point where it says, we ask the court to reverse the district court's refusal to unwind the ill-gained plea bargain because of error, and to remand this matter back to the district court for proceedings consistent. That's the view from 75,000 feet. Thank you.
Okay, thank you. Ms. Lifton?
Good morning again, may it please the court, the state occurs by Jody Lipton. Your Honor, I'll just go with your last question here about admission of a mutual mistake. It's not, and I don't believe, I reread the motion to withdraw, or our response to the motion to withdraw the plea. I don't know that the state ever agreed that it was a mutual mistake. If we look at what the prosecutor at the hearing testified to, which was what Your Honor said, it was, and well, I think that was at the plea hearing actually, that it was inadvertently left out. But if we look at what he actually says, is that the expectation is for probation, not the state and the defendant have agreed to a term of probation, no matter what his criminal history is.
No, but what I'm getting at is, it looks to me, I'm looking at the others. I recognize you have a good argument that, hey, it's up to the district. We're all former, I almost said old district court judges, former district court judges. We recognize the district court judge. But I mean, at first we expect candor with the court. And I know you weren't there, but when a prosecutor would come in and somebody's saying mutual mistake and they say, we inadvertently left that out, I would expect that they would admit, yeah, there was a mutual mistake, but then make your argument that even though there's a mutual mistake, it's up to you, Your Honor. We're anticipating probation. We look back at the criminal history and found out that the score was not C, but was actually B, and go from there. So that's what I'm getting at. I just wondered if the state had at least admitted, hey, we did have a mutual mistake here, but it doesn't make any difference in the outcome.
I mean, I guess the mutual mistake would go to the criminal history score, not to what they had pled to, if that's what we're saying, not to the sentencing agreement in the plea agreement, because I don't think there was a mutual mistake as to the state never agreed to probation. They agreed that the criminal history score from what the document was, which I'm not sure who makes that document exactly, but that's.
Just a second. The state agreed at that point that his believed criminal history was a C, correct? And the state knew that if he was convicted with a criminal history score of C, he would likely receive probation, correct?
Yes.
So how can you say now, well, it's just tough, mistakes on him, because it's not a C. I mean, you can't have it both ways. You can't do justice by saying, well, we suggest it's a C. You told the judge that it was a C, did you not?
I don't believe there was any factual findings in the record about that in the plea hearing. The plea says that they agreed to the standard sentence, standard number in the applicable box on the Kansas sentencing grid.
Which was probation.
Under the estimated criminal history score of C, yes,
Okay.
yes. But it didn't say the defendant will get probation.
Those
you
are all,
know.
no, those are all conditions, because you can't guarantee that the court's going to put somebody on probation or not. The court could say, no, I'm gonna send you to the penitentiary.
Right,
The court had the option to do that.
sure.
I understand, but these are all conditional things. I don't understand why you couldn't withdraw the plea and either renegotiate or go to trial.
I mean, I think that's exactly what the defendant tried to do here, and the district court disagreed and went through the Edgar factors and used the proper legal standard. And based on the language that was in the plea agreement of, I do recognize that, understand, accept the risk that if I am mistaken about my criminal history, I will be subject to the sentence that comes with my accurate criminal history. You know, I understand a mistake in my criminal history may subject me to a longer period of incarceration and a presumption of incarceration. I'm willing to accept this risk and enter the plea in order to obtain the benefits offered by the state as part of the agreement. So if you look at the whole language in this sentencing section, section 4, I think it's pretty clear. The
Who
defendant,
made the error?
well, I mean, a defendant's presumed to know his criminal history.
No. Who made the error? Who prepared this pre-sentence?
This criminal history worksheet,
Yes.
I don't know, Your Honor. I don't know
Was
that,
it your office?
I don't believe we do. But I don't know that there's anything in the record that,
Was it the probation office? It certainly wasn't the defendant.
correct, yeah, correct. I would
This is
imagine
an
that it's not.
official document. Who made this? Who made this error? It's a C and now it becomes a B. Somebody made a mistake. Who made the mistake? Do we know that?
I don't think there's anything in the record that talks about who drafted this criminal.
How do we know this is correct?
I think that it's an estimate of your criminal history. I don't know, Your Honor. I mean, I don't know that I can accurately answer that.
I don't think the defendant made it. I don't think.
No, I would agree with that.
He didn't make this document.
No,
So,
no.
And just, you know, putting myself in the position of Judge Osman, he's presented with a post-sentence motion to withdraw plea, which, if I'm not mistaken, is a manifest injustice standard. Had this been filed ahead of time, when both sides knew, quoting the prosecutor, that it had inadvertently been left out, then it would have been for good cause. And Judge Osman may have ruled differently there, but I mean, I understand why if you're in us, when we're facing post-conviction or post-sentence, motions to withdraw a plea, I mean, as you see, you do a lot of these. We affirm a lot because when they don't show it's manifest injustice, good cause is such a lesser standard. So even if we apply the Edgar factors, if we look at them, I mean, I'm concerned that this defense counsel, I know it wasn't Mr. Brown, and I know you weren't there either, but this defense counsel didn't advise him prior to sentencing of, hey, you need to file a motion to withdraw. Should we consider that as now that we're looking at the Edgar factors? Because one of those is competency of counsel.
Absolutely.
And it seems like it's fair to everybody, including the state. You know, send it back down, see what happens. We now know the facts. I don't know if you can do appellate mediation, but it seems to me that this is one of those few criminal cases where, you know, the state could probably say, hey, we understand. And because I understand your argument exactly. I mean, I think we've all been there where the judge says, for whatever reason, I'm not going to abide by the plea agreement. And he, you know, so in the event, but go ahead and complete your argument. You can tell we're concerned with this.
Sure.
Maybe not as much on the legal side as we, you know, sometimes, but I think we could get there by Edgar, the first factor of Edgar. But, you know, the concern is there that this just isn't, you know, one of our jobs is to try to do justice and be fair. And this just doesn't pass as one of my mentors used to say, the stinky cheese test.
Mhm.
But go ahead with
Well,
your,
and you know,
and I know you weren't there, and I'm not trying to criticize you at all.
no, and the state is the state, so, you know, I'm here on behalf of them and we
Sure.
are all one. So, I understand, Your Honor. I guess it's just these types of things, are done regularly. Pre-plea PSIs, are not done. So there are, you know, estimates about criminal history scores that happen in order to move things along. And the language in the plea agreement's clear. And I guess if we look at what he said during the plea hearing and then look at what he said also during the motion to withdraw the plea hearing, I guess I would emphasize that the plea was not to probation for the state there was no assurances made that he's going to get probation, I guess.
And that's fair, because that's the prosecutor said there on the record was he was anticipating probation, no guarantee of probation.
Right.
But there's really never a guarantee in a plea, which if we
Well, it's why we have plea hearings and not sentencing bargains. The state can't bargain a sentence. Never could, because it's always up to the court to impose the sentence. You can bind yourself to recommendations,
Correct.
but it's still up to the court to sentence. We don't have sentence bargaining. We have plea bargaining, and that's all you can do. We understand that.
Yeah.
But sometimes justice requires a second look at something. I join with Judge Bruns here and am concerned about this. The appearance of this is, how do you get around the Edgar factor of competent counsel? Why this wasn't stopped right then to say, Judge, we've got to have a continuance and I need to talk to my client about this to see if he wants to continue, because all of the rules change once a plea is entered and accepted.
Mhm.
You know that your many sophisticated arguments that you made before us, you understand those rules change dramatically. And he needed to know that, I think, but I'm
Sure. And I guess I would just go back to what I argued in the brief, which is looking at the Strickland standard, and this court would have to find that it's objectively unreasonable to have done so.
or we
And-
don't do so, and then we come right back on a 1507.
Well, or there's also, post-conviction or.
Because and maybe there isn't a message being sent, but I know Judge Osmond pretty well, known him for a long time. He, of course, was a prosecutor for many years. There's a reason why this gentleman's sitting here and not in custody right now. And it seems like he was trying to send some type of message. I don't know what it was.
I don't either, but I do know that he grants a lot of appeal bonds in my experience. So,
Bless his heart.
I will agree with you there that there are more, yeah, I have seen that, of course, not in the record, but.
Usually when it's presumptive probation, I'm not saying Judge Osmond would do it, but often when it's presumptive probation, they're taken, as you know, they're taken in custody right on the spot. And they don't come to appellate arguments.
Sure. I don't think I have any further presentation.
Well, thank you.
Thank you.
And you have certainly made a very good argument and very legitimate argument. Mr. Brown?
Are you timing me, Your Honor?
Well, I told you before, you don't have to use it all, but we'll give you the 7 minutes if you need it.
All right. 100 years ago, brick streets around the courthouse were laid by the mentally ill as slave labor. It was not objectively unreasonable. Now we hear that and we go, wow, really? Are you kidding me? 100 years ago, Indian children were not treated like they were humans. We know the black children were either. We think to our grandparents and our great-grandparents, how could they have been that way? That's objectively unreasonable. They didn't see it. I think 100 years from now, if this ball keeps rolling, they may look back at a time when district courts were run like, let's make a deal, like Monty Hall was in town. And if you look at I'm old enough, been around the 70s, I watched my fair share of let's make a deal. Sometimes you left with a rotten prize. And that's what happened here. And it only got stinkier. The cheese only got stinkier as this went along. And no, Jeremy McCulley didn't file that document. He didn't write on that document the case number that caused I think, confusion of not realizing that was a document from a case or so back. Prosecutor Manley said, Your Honor, I'd expect.
Well, let me ask you, who made the error here?
Court made the error when the court filed that document. That document was filed at the introduction of the case. I believe it was the court.
So who prepared that document?
I believe the court prepared that. I believe they took it from an earlier case, wrote the case number of this case on it, and slammed it in the docket. To look, we'll get them started with this worksheet that they should have done themselves. that my client should have sat down and said, let's go through this worksheet. Let's talk about your history. The plea bargain should have said, here's the history. Here's what Mr. Manley has done in the past and been convicted of. And here's how they stack. Oh, wow, what a concept, stacking. Due process requires that he understood that. The law requires, in its better days, not in this day when we put up with a lot of outrageousness at the courts, at the trial court level, in my opinion, through plea bargaining, I think this case is a wonderful example of it. Back in the better days, we said, you need to understand the ramifications here, son. You're going to hang in the morning. So we'll tell you what this means if you stipulate. But now it's like, oh yeah, we'll get rid of this charge, get this charge, and look, here you go. You don't get the all paid vacation to Tahiti, but you're leaving with a refrigerator. Well, he left with a box of stinky cheese. Prosecutor Manley, Your Honor, I expect the defendant's criminal history to place him in a presumptive probation category for this case. So we're not objecting to bond modification. That's how he walked out of courtroom at the plea bargain. Came back in 5 weeks later, 2 minutes before the hearing. Looks like you're going to jail today. Maybe the judge won't do that. Maybe the judge will agree differently. Well, the judge didn't, but the judge did grant him a bond. And the judge has sent a message. I think it's throughout his order, if you'll look at it and read it closely. I think he wants this tightened up, and I think he knows this court.
What relief are you asking?
Pardon?
What relief are you asking?
I'm asking for this to be remanded back to Judge Osman with the plea withdrawn for him to sort out what judicial doctrines need to be applied going forward.
You're asking us to reverse his conviction
Yes.
Is that right?
I'm asking you.
and remand
Yes.
for a hearing to withdraw his plea? Or are you asking us to say, Judge, his plea is set aside and begin again? What exactly relief are you asking? Because there's a difference.
And you know this law better than I do. I'm not a criminal defense attorney, but here's what I think, and I could be wrong. But I think if you rule in my favor, double jeopardy attaches and he can't be tried for this offense again. And justice.
My questions are pertinent then on what relief you're asking.
I'm asking this court to do justice. We're here seeking justice. That's all I promised my client. We would go forward and seek justice because this is not right what happened to you. Now, my opinion doesn't bind me, Judge Hill, you know that. Please do justice.
But you made it clear here what you want in terms of relief. And we have a right to ask you that.
Yeah. I can tell you, just withdraw the plea and we'll go back and start over again. That's a $5 cigar. Get rid of all of it and I'll buy a $100 cigar. Prosecutor says, we are all one. We are the government. We are all one. Reminds me, I was thinking about this case and it reminded me of Josie Wales, a great Kansan. Oh wait, he was in Missouri. Josie Wales, who said to Lon Waddy after hearing him, said, well, we can't trust the white man. That seems to be the message here, but we are all one is not the right message because listen to the prosecutor, Will Manley excused his failure for my briefing to correctly represent the criminal history during his plea bargaining with Mr. Culley because he does not, quote, dig into criminal history unless it's a case that I myself am completely responsible for. That's assigned to me. So if the assignment had been completely to Will Manley, we would have had a different outcome most likely. But he was a switch hitter. He was just stepping in for a small part in this play. So he didn't take it too seriously. And so he's not all one. It's not all one. It matters. How about Ms. Toothtaker, the other prosecutor that's also in my brief? Quote, I was not the person to draft this. Likely in the future, in instances in which I do please, I make it specific whether or not we're asking for prison. That's just, it depends on who's practicing. That's what she said right there. It depends on who's practicing. That's vagueness. I'm a civil attorney. If I was here arguing a commercial case and I could find that kind of vagueness against the people who wrote the contract, I think this case would be over. And I think this case should be over. Thank you for your time.
Thank you both. We'll take this case under advisement and get an opinion out as quickly as possible.
Yeah, the coffee pot on.
Sure.
Yeah, I dropped water on it.
Okay. We'll call our next case, State of Kansas versus Wilson. State your appearances for the record.
Michelle Davis, I'm sorry, I'm representing the water. I'm representing Mr. Wilson.
May it please the court, the state of Kansas appears by Drew Council Assistant District Attorney Carolyn Smith.
And Ms. Davis, would you like any, to reserve any time for rebuttal?
I would like 2 minutes, please.
How many?
2 minutes.
2 minutes, okay.
So Michelle Davis, they're representing Mr. Wilson in 2 minutes rebuttal. I think this case can be broken down into two parts. One part is what happens inside the house. It wasn't contested that Mr. Wilson shot a woman named Hill. And the issues that we raised in the brief based on that are the defense requested, if it's not contested that he shot, then the issue really is his defense was his state of mind, and that he said he was under the influence of PCP and there was evidence to support drug usage. So the defense requests an instruction on voluntary intoxication, and it also, for lesser included, instruction on voluntary manslaughter. The state had charged first premeditated. The jury ended up coming back on second. But the court denied the defense request for the intoxication and voluntary manslaughter instructions. And so those are the first two issues in our brief. It's our assertion that basically the judge weighed the evidence and decided that it shouldn't be given, rather than looking at the evidence in the light most favorable to the defendant. And there was evidence presented to support the intoxication.
How long was it between the time he, I think it said, they didn't call it a blunt, what was it, a wet cigarette, a wet, between the time he started to smoke that or smoked it in the kitchen when he's talking to her and the time that that he shot her?
I'm not sure that was really clear. My understanding of the evidence is that he has this cordial discussion with Hill in the kitchen, and there's other people in the residence. It was after that discussion was over that
He goes out and argues with somebody else.
No, they had their discussion. It looks like everything's good there. And then he smokes the blunt and he starts sort of interacting with some other people at the house. And he gets into it. He goes to the back of the house and he gets into it with this gentleman by the name of Bond. And Bond's the one that talks about how his behavior changes and he starts acting this way. And my understanding, it was pretty quick, but I don't remember a specific time frame.
Well, what I'm wondering is, what evidence is there that it would have kicked in by then? I mean, like if you go out drinking or whatever one may do, it takes a little bit of time for it to kick in. And I'm wondering what evidence, is there any connection between, okay, here's when he smoked it and here's some evidence of when it started affecting him and affecting him so much that he shouldn't have responsibility for.
Yeah, it was the other individual who was there that testified about that, about how his behavior changed so much.
The jury heard all of that evidence, correct?
Right, and then they also had, after he leaves the house, he goes to home and he gets on a Facebook Live for 2 hours. And I guess he characterizes he's ranting and raving. So they got that evidence, and then the police go over to his house and arrest him. And he's interviewed by the detective and probably still under the influence. And he's talking about how he doesn't remember how he had smoked this and it messed him up. And he doesn't know what happened. He can remember the gun jamming. He can remember being there, but he doesn't know why he did what he did.
So there was no denial that he had been influenced.
Yeah, I mean, I think it's pretty clear, this guy, they said he smoked.
That's not in doubt.
He smoked a wet cigarette and then his behavior drastically changed. And he seemed to get in some kind of delusional state where he wanted this man to take this property out to his car. His car wasn't there. He had been driven to the house by Massey. He didn't even have a car there. And this guy kept trying to tell him that. And he's got his gun and there's this loud commotion. And they get it, the guy gets angry, the Bond gets mad about he'll be, and they start a physical altercation. So this was a very sudden thing. This wasn't a situation where you got guys talking trash at a party for 20 minutes and then they walk outside and somebody shoots somebody. This was a sudden escalation.
Is this a clear error standard?
No, because the instructions requested were under the state harmless error standard, or arguably the federal, because it was his theory of defense. And that he did not get instruction on his theory of defense. And so the state's got the burden to convince you that the error was not harmless. I always get confused with that, was harmless, yes.
What was the court's reasoning for not giving?
Because the court looked at all the evidence. And the court said, yeah, looked at all the evidence, including the evidence favorable to the defense. And I don't think it's justified. And the court did that with both of them. So basically, the court's making the decision here and not saying, is there some evidence that a rational jury could use to find? And there was evidence here that a jury could use to find, this might say his intent or to find voluntary manslaughter. So that's the error here. They didn't view the evidence like most favorable to the defense, which was the standard.
So this was a jury question? Then,
Yes.
and not a court question?
Yes. So that's one issue. And the second is that he leaves the house. There's a neighbor outside. This is daytime. My understanding, like early afternoon, if not noontime, somewhere around there. The neighbor with his two small children, 10 to 15 feet away. He says, I'm walking, 4 and 8 year old. And he comes, Mr. Wilson comes out of the house and points a gun at him, and the neighbor, talks to him, and Mr. Wilson leaves, right? And so the state obtains an ag assault conviction. What we challenge is aggravated endangerment, because there was no evidence of actual harm to the kids. And there's insufficient evidence of aggravated endangerment, and also the judge did not give the misdemeanor endangerment. And so this is kind of tricky, because there's got to be some kind of line here between endangerment's not defined, but generally it's harm. There's some case law saying it's harm. So if one is maybe endangered and two is endangered, and because maybe endangered, the misdemeanor is somewhat vague. There's case law that says there has to be, and you instruct the jury when you give the misdemeanor, which was not done in this case, there has to be a reasonable probability, a likelihood of harm to the child. It's not a possibility under the misdemeanor standard. Jury wasn't told that because they weren't given that instruction. All they were given was the felony that says they were placed in a situation in which their life, body, or health is endangered. That's it.
Was the misdemeanor requested as well?
No. So I'm on a clear error standard.
That's a clear error standard.
Yes. The difference here, like the Patillo case that's cited in the brief. So this was a case where there was an actual shooting. That it's an older child inside the house. The bullets from outside the house. So the child's just playing, and all of a sudden there's gunshots, and the child's running and scared. The child testified, or somebody testified, the child was harmed, right? In this case, there was no testimony. Nobody asked. The state never asked, how did this affect your kids? Did you talk to your kids about this? Did your kids see this, right? All we've got is a man with a 4 and 8 year old saying they pointed the gun at me and how he felt, and he was under ag assault, right? There was no testimony.
Under these circumstances, he pointed the gun at the children.
Well, the man and the children are together, and he's saying,
Well, he pointed the gun at them.
right, but there has to be evidence of harm.
Why does there have to be evidence of harm for aggravated assault?
There doesn't.
There doesn't have to be.
No,
So
not for the man.
the additional element here under endangerment is you have to show some harm,
Right.
correct? So
The
is it
children,
really a lesser included offense to
Well-
aggravated assault?
to aggravated endangerment. I'm not challenging the aggravated assault. I'm challenging the aggravated endangerment.
All right.
And you're right, it is almost like an aggravated assault of a child, but, so that's a problem. I mean, one, there wasn't evidence in this case to show that there was harm. And then two.
Well, don't we have cases? So, I'm looking at one here, Herndon, the crime is placing a child in a position of peril, not in causing the actual injury that may follow. Here's another one, Martinez, that says pointing a loaded gun at an individual immediately places that individual in danger. So we know it was loaded,
Right.
at least at one point,
Right.
obviously.
My analogy is if I get in a car, I'm in danger.
I consider myself, when I drive on the roads of Kansas, I'm in danger. If I put a child in a car, I'm putting them in danger. Just to me, it's a dangerous activity driving. That's why the misdemeanor says unreasonably causing a child.
Well,
Because we have
unreasonable, I
to-
think,
Right.
pointing a loaded gun could be, at anybody could be unreasonable.
Well, no, but that's the misdemeanor standard, right? For the felony.
Right, I
standard-
mean, if we went to the misdemeanor, but I mean, for the felony standard, the cases say pointing a loaded gun at the individual immediately places that individual. in danger.
Well, there's one case that says that.
Yeah,
That's
well, and-
That's a panel for 2014, the Martinez case.
Well, we love certain panels, but Hernan is a published case. The crime is placing a child in a position of peril, not in causing the actual injury that may follow.
Well,
It seems like pointing the gun made it at kids, made it aggravated, and whether we agree or not that he was pointing at the kids, obviously there's evidence that he
Okay.
was pointing
so
at
if
the
the misdemeanor, to have a misdemeanor endangerment, you have to have a reasonable probability of harm to a child. If that's what the misdemeanor standard is, how do you then distinguish it from the felony?
Wasn't the aggravated the fact that it's a loaded gun?
No, that's the ag assault. That's the ag assault. The aggravated endangerment, that's what I'm trying to say. What's the difference? The aggravated endangerment is you did endanger. The misdemeanor is you may be endangered. So to me, you've got to have the difference here. There's some case law I talk about. The misdemeanor would be making methamphetamine in the garage. The aggravated would be the garage catches on fire. The misdemeanor is you're speeding with a kid in the car. The aggravated is you come close to causing an accident. There's got to be some difference between those two. If the misdemeanor is a reasonable probability of harm, and in order to get aggravated endangerment, there's got to be more. And the problem is that we don't instruct the jury on that. All the jury's told in this case is in a vacuum, they're given one instruction, no misdemeanor, they're given the aggravated endangering, and they're told that means that you recklessly cause a child to be placed in a situation where their life, body, or health is endangered. And it's your rationale. Well, you pointed a gun. You endangered them. But that's not legally sufficient.
So Martinez panel, whoever, I hope none of us are on that panel, is wrong.
Well,
Why is it wrong?
I'm not sure, Martinez, they may have put on evidence that the child saw the gun pointed at them and the child was traumatized. Maybe they did that in Martinez.
So you're
right?
saying if they would have called one of the kids in this case and they would have said, hey, we were scared,
Yes.
then it would
yes.
be okay. But if they don't
Yes.
call the kids, then the fact that dad said the kids were there and testify isn't sufficient.
Well, they have to be harmed. I mean, what dad is sort of saying is, I'm scared, they're pointing this gun at me. So they're putting my kids in danger. And to me, that's the misdemeanor version. You're pointing a gun at me, there's a probability, I'm scared my kids are gonna be harmed, right? That's the misdemeanor version. Now, if you had fired the gun and shot at these people and the bullet missed them, then to me, you got the felony, right? I mean, it's happened. That's the difference. And the jury just wasn't given that option in this case. So I'm probably way out of time.
Well, you're at 12 minutes, and you wanted 13, so you've got about 30 more seconds here.
Okay. I don't think I have anything else to add other than just on the cumulative error. My cumulative error is putting both instructions together. So they're both requested instructions. And I said cumulative, if the judge had given both the voluntary man and the voluntary intoxication, those would have helped each other because the jury could have thought, okay, he's saying he didn't intend to kill. He's intoxicated. Maybe let's call this a knowing voluntary manslaughter. And that's why I put those together in the cumulative error.
But the misdemeanor one was not requested.
No, and that's not in my cumulative error though. I
So
didn't want to do that.
You're following our friends on the third floor.
Right.
And you're not
Right.
relying on a uncontested.
Right.
instruction. Okay.
So those go together for that reason, because the ball man has a knowing mental state, which the intoxication, the jury could have felt like that was a mitigating circumstance and gone with that lesson. If they give them the voluntary intoxication, that's why I put it together. All right, thank you. I'm sorry.
That's fine.
I'll come back.
Okay, thank you. Davis?
May it please the court, Carolyn Smith on behalf of the state. Your honors, I'd like to jump straight to the misdemeanor child endangerment argument. As your honor stated, the panel of this court decided in Herndon that the crime is placing the child in a position of peril and not causing the actual injury that may follow. There wasn't a requirement to show actual harm to the children in this case, just that pointing a gun at them placed their life, their body, or their health were in a place of endangerment. The difference between misdemeanor May and felony actual endangerment is there's a child in reach of a gun. There's a gun in this area and they could potentially reach it. They may be injured in that case.
Like a gun on the coffee table that a toddler could get to,
Correct, Your Honor.
opposed to somebody picking that gun up and pointing it at the kid.
Correct, Your Honor. That's the difference. And that's why in this case, misdemeanor child endangerment wasn't a necessary requirement. Would a conviction of such been sustained? Likely. But not giving it isn't a standard, is a clear error standard here, and is one that the defendant can't meet. Because the defendant in this case ran out of the house, stopped in front of the neighbor and his two boys, pointed his gun at them, and stood there pointing his gun at them long enough for Mr. Reedy to say, we're not a part of that. We're gonna go inside, we're cool. And then he ran away. There wasn't a requirement that the firearm be shot. There wasn't a requirement that an injury occurred to the children. If that were the case, we'd have a completely different crime here.
Counsel, if you're done with that, I'm more interested in the failure or the refusal of the court to give the voluntary intoxication instruction.
Yes, Your Honor.
Tell me about that. Our standard of review is harmlessness, and it's up to you to show us, right?
Yes, Your Honor. And in this case, I believe Judge Bruns asked, what evidence is there that he was intoxicated? There isn't any. We have,
Well, wait a minute. He smoked a cigarette that was soaked in formaldehyde. He inhaled formaldehyde into his lungs. There was testimony that affects him, as it probably would affect anybody. The jury heard all of that.
there was one witness who testified that the defendant's demeanor changed. There was a different
How
witness.
many more do you need? Does the law say you have to have two witnesses that his demeanor changed?
No, Your
How
Honor.
many does it take? I mean, the point is, the judge made fact finding here, right?
No, Your Honor. The judge in this case stated, I've reviewed all of the evidence, and that includes both the state's evidence and the defendant's evidence. He
What
looked
did-
at all of it.
Listen to those words. He reviewed it. Judgment is being made there. That's weighing of evidence. That's what a jury does, isn't it?
I disagree that that's what the court did, Your Honor. The point, before giving an instruction, the court has to view the evidence and determine, is there any evidence to support giving this instruction? That would take looking at everything. The court didn't say, I'm weighing this versus that.
So there's no evidence in this record that he wasn't influenced by drugs.
There are only 3 points of evidence that would have supported this instruction. That's,
So that's not enough?
no,
Three
Your
point-
Honor.
3 points is not?
That is not enough, Your Honor, because the evidence included the consumption. One statement by the defendant that he was high while he was in his interview with the detective, and one witness's description that that was the defendant's demeanor. But there was nothing to show that this wasn't just who he was. There wasn't anything to show that he didn't have control of his faculties. And there wasn't any evidence to show that he couldn't reason, remember, plan, or exercise his motor skills, all things that he did throughout these events. He had a full conversation with the
So in
victim.
order to give this instruction, you say, oh, there must be evidence of all of that. Is that what you're saying?
Any one of those things, Your Honor.
So just in that list you're taking from Benton Court or whatever it is, loss of memory, loss of ability to plan, or loss of ability to exercise motor skills.
Yes, Your Honor. I believe it's also cited in State v. Morris, a 2020 case from the Supreme Court. Additionally, in Hernandez, another Supreme Court case, there was heavy emphasis on the defendant's ability to provide details of the incident, which is something that he does multiple times through the many recordings that are of him in this case saying, I know I killed her. I'm glad I killed her. I would do it again.
Well, he even gave a reason, didn't he? That something about her allegedly selling her son for sexual favors or something like that.
Yes, that was another thing that the defendants talked about,
Doesn't
saying
that sound deranged?
it could be deranged, Your Honor, but there is the court isn't in a place to assume or put together hypothetical situations to.
He smoked a cigarette soaked in formaldehyde. Doesn't that lead to craziness?
It's possible, Your Honor. There was no
Yeah.
direct evidence that the wet cigarette was one smoked in formaldehyde, or if it was just one laced with PCP.
But that was for the jury to decide, wasn't it?
The jury was able to decide that. They still heard the evidence.
But did they need to have the legal standard given on how they should approach that? The point of an instruction is they should have the law and understand the law while they're making that decision, and that's what was denied here. What standards did this jury have to evaluate this testimony about the drug use?
The jury had the instructions for the crime themselves, as well as the required culpable mental states that they had to determine.
That's right.
And in this case, he was initially charged with premeditated first-degree murder. The jury looked at that, determined that the facts didn't fit this case. He didn't go over there to plan it. I believe he even said so in one of the recordings that he didn't intend to kill anybody on this particular day. But that they agreed after reviewing the evidence, after hearing about this wet cigarette, about hearing some of the stuff that he did, even hearing some of his comments in the various recordings, that he still intended to kill this victim based on whatever he believed.
I think you're correct when you're saying that the jury made this evaluation because of the verdict that was rendered. They made that evaluation. My problem is, were they given the correct legal standard in how to consider that evidence? And that goes to the heart of this issue. I'm not talking about the clear error on the second instruction issue. I'm talking about this one because the burden's on you to show us that it's harmless.
Your Honor, it's harmless in this case because of the volume of evidence against the defendant, that he had intent. He was able to articulate that intent over and over and over again while describing the events. Whether or not details of that completely line up, it's not uncommon that memory is malleable and changes based on our own personal perceptions. But the actual killing, why he did that killing, and how he felt about that killing were well articulated over and over and over again. And that's why, even if it should have been given, not giving it was harmless.
Before we get to harmlessness, first, of course, is what's your position? Was it factually appropriate to give this?
No, Your Honor, because
When the evidence viewed in the light most favorable to the
defendant.
And why wasn't it not factually appropriate?
There was not enough evidence here to show intoxication sufficient enough that he could not form the intent. He didn't lose his ability to reason, to plan, or to exercise those motor skills as is a requirement. He didn't lose any of his faculties during this time.
And so they were your position, because you mentioned State v. Morris. State v. Morris if I recall correctly, somebody smoked meth. And then the Supreme Court said, well, that's not enough in and of itself to get this instruction. Is that basically your argument, that the fact that he smoked it isn't enough in and of itself?
Yes, Your Honor.
Now, then they went on and talked about a coherent narrative that he made. And I have not went back and read the facts of Morse. Maybe I need to do that, but you know, did Wilson make a coherent narrative here?
I believe there was a coherent enough narrative, Your Honor. There's a lot of things that went on in that Facebook video. He didn't just talk about the killing. He talked about other grievances he had, other feelings he was having. There's a lot that went into that video about his beliefs and what he was feeling at that time, but that doesn't automatically show that he was intoxicated. Those could have just been his feelings.
Or he could have been, I mean, at least reading Morse, it looks like the fact that you smoke meth, or in this case, PCP, whatever he did, you got to have more. And you're saying you can't show the more. You can maybe show that he was incoherent hours afterwards, but not now.
Correct, Your Honor.
So I take it, though, you would agree it would have been legally appropriate to give this, because they at least made the argument.
Yes, Your Honor. This would have been legally appropriate related to the murder count. It is a legally appropriate defense for an intentional murder.
So then if you are wrong on that it's factually appropriate, then we get to the harmlessness.
Yes.
And explain to me just your shortest answer you can on, and you're not taking too much time, but I mean, just so I understand it, why would this be harmless if it was factually appropriate?
Because of all the evidence in this case that showed he did it on purpose, that he did it intentionally, not just the recordings where he states so over and over again that he was happy he did it, he would do it again, but the evidence of the witnesses in the house who heard the first gunshot, heard a brief exchange between the victim and the defendant, and then heard the second gunshot. I believe the victim's words were, "It doesn't have to be this way," and his were, pardon my language, "fuck you." Right before the second shot. That, along with the recordings, along with the evidence that he then ran from the scene, ran home, and then just started talking about it.
He remembered something very specific, but I don't know if there's any evidence other than his memory, which could have been right or wrong. He had a specific memory, even later, that the gun had jammed. Is there any evidence in the record that the gun had jammed other than his recall that that's what happened? I mean, did somebody else at least say, yeah, you know, he shot once, the gun jammed or whatever, and then he shot again?
There isn't, Your Honor. The jamming of the gun is the most confusing bit of evidence because it's unclear whether that occurred inside the house or outside the house, and nobody was able to articulate to my memory, any specifics of when that had occurred.
If it did happen, that's a pretty specific detail that he recalls later. But you're saying we don't know whether it happened or not, or even if it happened inside the house or outside.
That's correct, Your Honor. Your Honors, I believe if there are no other questions, I would stand on my brief and I would ask the court to affirm the convictions in this case.
Thank you, Ms. Smith. Ms. Davis?
Just briefly, I do want to point out that the two people saw him smoking the wet cigarette, both Massey and the man saw him smoke the wet cigarette, and then he got into it with the man. You know, it's interesting. He talked to the detective that night, and part of why the state says, oh, there's all this evidence against the instruction is because he gave so many crazy and inconsistent statements over time. What he did tell it would have been interesting as a defense attorney to say, why did you get into this altercation with this man? Why were you trying to move this property? Why did you run outside and point the gun at these people? And you know why the defense couldn't ask that? Because he told the officer, I don't remember, I don't know what happened. I don't know. Something must have set me off. I don't know what it was. I smoked PCP and it messed me up. So there's no defense testimony. He can't testify about the altercation because he doesn't remember any of it. He didn't remember any of it that night. His defense attorney can't ask the cops about it. He can't deny pointing the gun at the man because he doesn't remember any of that. And that's the night after this happened. He's got no mental ability here to reconstruct events. So he's gushing and he's all over the place, but there's nothing here about what actually happened. So that evidence supports, that evidence I just told you supports the instruction just by itself. Even if there's a bunch of other statements he made later that are inconsistent. That concludes my remarks. Thank you very much.
Okay, thank you. Thank you both. And again, we'll take this under advisement and try to get an opinion out as quickly as possible. And our final case this morning's docket is I-135 Auto Auction LLC versus McMaster. Would council please state their appearances for the record?
Your Honor, Kevin M. McMaster appears on behalf of the appellant, Kevin M. McMaster.
So you're representing yourself today.
Yes, Judge.
Okay.
Craig Schultz, representing Linda McMaster.
Okay.
Good morning, Jeff Carmichael with the Morris Line firm out of Wichita. I represent I-135 Auto Auction LLC.
Okay. And I noticed we do have a cross appeal. Now it's related, closely related. And we do technically have two different, well, I don't know that we have two different appellants, but we have an appellant and I would take it, aligned party together. So have you discussed how you want to present your oral argument?
Yes, Judge. Our hope is appellant will take 7.5 minutes of the 15 minutes. And then for the most important party, my wife, we reserve 7.5 minutes for the cross appellate.
Okay, you're really testing my stopwatch skills, okay? But if you do that, what about rebuttal? Do you want to, you can do it how you want to, but my suggestion would be more like you divide it up, 5 each or something, and then you still would have some time for rebuttal because there is a cross appeal that you probably want to talk about at some point.
Well, that's fine. I anticipate that Mr. McMaster would go first, at which point.
Well, we're not going to play ping pong here. Let's just, we're all professionals. You can make his argument. You can make your argument. He can make his argument, and then you get rebuttal, and you know exactly what the issue is.
Yes.
So, I mean, if you want 7.5 minutes each, then fine, but that's 15 minutes, we're done. I mean, we didn't grant any extra time on this, so we've got 15 minutes per side. Divvy it up as you feel appropriate.
Use 15, Your Honor.
Okay, and you don't need to use it all if you don't need it.
And we'll split ours in half.
But do you want to save some of it for rebuttal? Or not?
No, my thought is we'll do 7.5. Mr. Carmichael will do his 15.
Okay,
And then Mr. Schultz will get 7.5.
okay.
Unless he wants to split that up with me somehow.
So you're waiving rebuttal?
No, what he's saying is
Well,
they're
the
gonna
cases
be,
aren't identical.
yeah, are you,
You're the appellant and you're waiving rebuttal then?
Unless he wants to reserve some of his 7.5 for my rebuttal. Yes,
Well, you have to make an agreement with him, not with us.
we'll figure it out on the fly if that's all.
No.
No,
You need to tell him.
yeah,
So he knows.
so no.
okay,
So you do 10, then you'll go, and then you'll do 5. Is that what I just heard?
if we do the rebuttal bit, then it's, I'm going to do 8, he's gonna do 5, and that leaves me 2.
2, okay, 2 for the rebuttal. Okay,
You can do the stopwatch thing.
yeah. So if you see me playing with my phone, I'm keeping the time, not checking scores. So, but the Royals are doing quite well this year. So,
Yes,
okay.
any chance you can tell me when I've used 5 of my first 8?
I will try to do that. So, Mr. McMaster, you may proceed.
Thank you. May it please the court, counsel. This is an appeal from a judgment entered following a jury trial. The facts were not complicated, but they are linked because it involves 2 separate actions. Because of the time constraints, the facts will not be separately addressed. What ended up happening is, as a result of the results of an underlying case, Auto Auction sued the McMasters for malicious prosecution. And this appeal is from the judgment rendered against one of the defendants, me. Pointing out is the key that the underlying action did not meet the standards for which Auto Auction ought to have been able to pursue its claim of malicious prosecution. The elements clearly absent and missing are the underlying action was initiated and continued without probable cause. That didn't exist. The underlying action was prosecuted with malice. That didn't exist. And the underlying action terminated wholly in favor of Auto Auction, and that didn't exist. The key is the underlying action was initiated with probable cause. Probable cause only needs to be shown because the defendants in the malicious prosecution action had a reasonable belief in the Miller case, that in the Borowski case is a reasonable suspicion that the claim had merit. And in this case, the facts are, regardless of the arguments made by opposing counsel, are that a vehicle was repossessed. Contained in that vehicle was personal property that the repossessor had no right to take. That, based upon black letter law, is conversion. Conversion is the unauthorized assumption or exercise of the over property that isn't there. It's a strict liability tort. The converter does not need to know that they have somebody else's property or who the person is. The conversion has occurred. Now, there might be issues down the line as to the damages, the amount, or other things, but the key is that's a conversion. There was no dispute while there were claims. When you look through the whole record, the McMasters' property was in the vehicle that was repossessed. And there is no dispute to the fact that Auto Auction wouldn't return the personal property out of the vehicle unless the owner of the vehicle returned the keys to the vehicle. That's not something that the lien holder or the person who's in control of the property has the right to claim. Therefore,
As I understand it, when you approached, you didn't know the make or model of the car,
correct.
and you didn't identify yourself as the owner of the car,
That's because I wouldn't know.
and you simply demanded it back.
Well, I did not demand the car back.
No,
That-
you demanded the return of the
Personal
garage door
property.
opener.
Yes. But I didn't identify it as a garage door opener. I did.
Well, we know now it's.
Right, no doubt. Now, I knew the color of the car and I knew the make, but not the model. But the key there is, you
How
know,
did they know that you were who you were?
well, they could have asked me. I showed them a business card. I had identification on it. The property in the car identified my residence, but none of that was offered. The key there, though, is that was the only vehicle that was repossessed and put in their storage lot that night. So it's not like it would have taken something extraordinary to figure out which vehicle it was. It's like also the person who refused anything could look out the window and see the car. Now, it was a distance away, but that's the key is, and the key is at least there's evidence there of a conversion. There's evidence there that the converted property wouldn't be returned unless, which makes it a viable claim in the underlying action.
As I understand it, Elaine Parker then took her keys into the repossessed vehicle and obtained your property, correct?
Yes, and her property.
And she gave it to you. And
Yes.
she got her property as well.
Yes,
And this is what, a couple of days later?
yes.
All right, and then you sued them.
No, the lawsuit was filed, the lawsuit was served, and then Elaine Parker got the opportunity to get her property out. That's part of the third element, which has to do with the resolution was not wholly in favor of auto auction. First, we say malice was absent. Well, I don't need to address that because the Roe case clearly says if you have probable cause, the absence or presence of malice doesn't matter. But what you're talking about is it is undisputed that the lawsuit was filed, the lawsuit was served before anything was done by auto auction to secure, identify, or return the personal property. And that's why we talk about auto auction not prevailing as a whole in the underlying action.
You're at your 5 minutes, just you wanted me to give you a heads up.
Thank you. Another important fact in connection with the underlying case is auto auction filed a motion for summary judgment. The summary judgment was denied. We submit, and that's supported by the Prorupski case, that when you have a motion for summary judgment denied in the underlying case, that is presumptive bar to subsequent lawsuits for malicious prosecution. Losing the summary judgment motion meant that there was an issue of fact regarding evidence and or an issue regarding the law, which means that in the underlying case, there existed probable cause. And if you look at the reason the summary judgment motion, the motion for a directed verdict at the 3 different times at ASCO were denied is each time the court relied on and focused only on evidence presented at trial in the underlying action. And that clearly is not allowed. And that clearly violates all the rules with regards to how a court is supposed to strictly scrutinize claims of malicious prosecution. And we'd submit that if you look through it at each stage of the game, there were 3 things that auto auction missed. There was probable cause in the underlying action. There wasn't evidence of malice, but again, that's not important. But most important is the fact that there was not a determination wholly in favor of auto auction because the lawsuit's what caused the return of the personal property. I'll reserve the rest of the time. Thank you, Judge.
Thank you. Mr. Schultz.
No.
Yeah, they wanted to do 8 and 5, and then you'll go 15, and then I go 2.
I lost track.
Yeah, I wrote it down. I had to scratch out some things, but so Mr. Schultz has 5 minutes.
And primarily representing Linda McMaster at the trial, basically, I would simply point out a couple of things. First of all, advice of an attorney is an absolute and complete defense to a claim for malicious prosecution. I could read the PIC construction to you, but you all can read that yourself. So long as the facts known to her have been fully and truthfully given to the attorney, there is no evidence that she said anything to the attorney that would have been incorrect or inappropriate. In fact, what she really said to her husband, let's just go ahead and be clear about this, is, please take care of this. She was frightened that this car door or garage door opener was in the car with an address on it, some unknown location, maybe not the most unscrupulous of people, but who knows? And so she's concerned and she says to her husband, please take care of this. And at that point in time, he took care of it. And what he did, while we believe to be completely appropriate, is largely not material to the issue of advice of attorney. Because she said, please take care of it. And she let him handle it. And he did it. And so I think that's why the judge granted summary judgment in the second case or this particular litigation and excused her from the case. Now, going back to the
That
underlying.
was her entire involvement in this case. She turned to her husband and said, take care of this.
Basically, she said she told him what had been told to her the night before when they came to get the car, but she did not enter an appearance or get involved
He
in.
didn't go out to the auto yard and
Right.
found on the desk or whatever. And so that's it.
Pretty much.
And in the lawsuit then, the court granted a judgment in her favor.
He did at the end of the evidence.
Yeah.
Now, relative to that, and I'm going to argue just a little bit if I can, that, you know, she also filed a motion in the underlying case, you know, there was a motion for summary judgment. I'm adopting that Probruski type argument.
That's right.
And I can go into more detail about that, but I think when you put those facts together and you look at the cases cited in Probruski, I think as a practical matter, there is no way the judge could not have granted a directed verdict at the end of the evidence, which he ultimately did.
And that's basically what happened. It was on advice of counsel. It's a defense to malicious prosecution.
Yes, complete bar.
It's an absolute bar.
Yeah, and so the judge granted that, and as a practical matter, that's where things ended up. But we also have sat through that and thought at that time we would have been entitled to judgment anyway, because we thought also the conduct, as a practical matter, the conduct of Mr. McMaster as the attorney, we thought was completely appropriate and not inappropriate.
And just, I want to make sure that I understand this correctly. None of the sanctions were entered against your client. Is that accurate?
That's accurate. And that's all I have then. I don't know if I used 5, maybe he can have an extra minute.
You used 3.5. So yeah, if he needs an extra minute, he can have that. Okay, Mr. Carmichael.
Good morning, Jeff Carmichael, appearing on behalf of I-135 Auto Auction LLC. Let me start with the issue that Mr. McMaster concluded with, and that was we were successful in the litigation because the garage door opener was returned. Those two items are totally unrelated. There's nothing about the litigation that was filed that had anything to do with the return of the garage door opener. That's pure fantasy. The garage door opener, there was a procedure through Speedy Cash where the owner of the car could go there, present documentation that I own the car, I want my personal property back, and get their personal property, and that's what was done. That had nothing to do with the lawsuit that was filed. Totally unrelated issues. There may be a correlation, but there's no causation between those two events. Secondly, on the issue of the cross appeal, you know, advice of counsel is not just a phrase that you use and then just it goes away. There had to be advice given, advice relied upon, and the evidence that we established at trial was extremely clear. No evidence was sought, none was provided. They never discussed it. So there can't be advice of counsel.
Well, remind me of the facts here. She was there when the car was repossessed, correct? And did she talk to the people that was hooked it up and hauled it off?
She was not there.
She was not there?
She was on the phone,
Okay.
talking to her friend about what was going on.
Elaine?
At her, yeah, Elaine Parker.
Was Elaine there?
Elaine was at her home.
Okay.
And she called and sought to talk to Linda McMaster.
Okay.
And they had a conversation on the phone, but Linda was not present while the car was being repossessed. But she was told it was happening. You know, there's no asterisks in advice of counsel except when Kevin McMaster and his wife are involved. These requirements exist. Well, you've got to have advice given. You've got to have reliance. There was none. More importantly, on the cross appeal, the judge found that there was no probable cause for Linda McMaster to have sued. But then he somehow makes a finding that, well, there's no evidence of malice, and so I'm going to dismiss her based on a lack of malice. The problem is, under Kansas law, under malicious prosecution, you can infer malice from the lack of probable cause. The judge found there was no probable cause, but then said, well, I'm going to unilaterally rule, I'm on my own as a matter of law, no malice. It's impossible. The jury could have inferred malice the lack of probable cause the judge said existed.
If we rule in your favor on the cross appeal, what remedy are you seeking?
This was more or less a protective filing, Your Honor. We recovered from Mr. McMaster every dime we asked for.
So if we were to reverse the judgment, basically, you're basically making an alternative argument that it should go back as to both defendants.
Correct. And I think if we're successful against Mr. McMaster, that there is in all likelihood probably no damage then for Miss Linda McMaster. Because we recovered everything we sought in the underlying action. In addition, we got sanctions plus costs. So
Judgment has been satisfied.
correct. Let me then back up to the issues raised by Kevin McMaster in his appeal. And the issue is probable cause. He says, hey, there's no probable cause. Probable cause, again, has to have meaning. Probable cause as defined in Nelson versus Miller is cause to institute a proceeding. You got to have a basis. It's not a Ouija board. It's not, did I have a dream about this? It is, are there facts? Is there information that is available that you could have access to that would give you probable cause for filing a suit? Keep in mind in this situation, the automobile is repossessed. And let me make this absolutely clear. My client had nothing to do with the repossession. That was Speedy Cash. And if they had a complaint about the way the car was repossessed and things that were done wrong in the repossession, they should have sued Speedy Cash. My client did nothing wrong.
But your client had the garage door opener.
Supposedly. Although my client
Presumably.
was never aware of that. Again, you've got correlation, but not causation. You've got Elaine Parker who goes to pick up her personal property, but nobody goes with her. Nobody sees what she picks up out of the car. Nobody from I-135.
How did that take place? Did she just come in and then they give her the, or did she wander back to the yard and take it out of the car herself?
She came with a form from Speedy Cash that Speedy Cash provided to her that was filled out. And she had to present her ID, which she did, to the folks at I-135 where the car was being stored. Showed her ID and the form that authorized her to go get property out of the car. And then she personally went and got it. Nobody from I-135 went with her. Mr. McMaster was not present, nor was Linda McMaster. It was Elaine Parker. What she did, nobody was present. And she took whatever she wanted out of the car because it was her personal property. I-135 didn't care. They were simply obligated to give the vehicle back to Speedy Cash if Speedy Cash wanted it, in the condition in which they received it. And Speedy Cash was authorizing the removal of personal property by Elaine Parker. Had nothing to do with my client. But then you have the issue of probable cause. Was there a basis to sue my client? You know, the car's repossessed one night and the next morning, Kevin McMaster goes to I-135 and he sues that day a company called I-35 Auto Recovery or something that has never existed. It is not an entity that ever was any involvement in this case at all. It never existed. I-135 was storing a vehicle pursuant to an agreement they had with Speedy Cash. That was my client's involvement. And what was important was a finding by the district court judge that when Kevin McMaster came in the next morning, demanded to get access to the vehicle that wasn't his, that he couldn't identify. My client
He didn't
said,
even know the make and model.
yeah,
Do the color.
yeah. Well, you know, a color doesn't do you any good in an auto auction setting because there's hundreds of cars. I bet there were 30 or 40 or 50 green cars that morning, if that was the color. It doesn't matter. He couldn't identify it. He had no right to get access to that vehicle.
What about his argument, though, that Perutsky says that the fact that the district court in the underlying lawsuit denied the motion for summary judgment is a presumptive bar to subsequently filing suit for malicious prosecution.
And again, Judge, you look at the issue of why summary judgment was denied in that situation. It wasn't based on findings that there were factual issues that precluded it. It was that it was such a mess in terms of the issues being raised that the court simply kicked it over for trial. There were no specific findings that would allow a defense that would allow a claim that is being asserted in this situation.
Ordinarily, we can't even consider ruling on a summary judgment motion if the case goes to trial on the merits,
True.
because it's all interlocutory.
It was
Summary judgments are interlocutory. We review final judgments.
correct. And I believe in this situation, when there is a final determination made by the trial court, by the jury in our situation, of wrongful conduct, of no probable cause, of malice, and a recovery of damages, that is what should be affirmed in this situation.
The probable cause is at least generally a question of fact.
Absolutely. And in addition, like I argued before with regard to Linda McMaster, if there's probable cause or an issue of probable cause, the jury can infer malice from that probable cause finding. Although it doesn't go the other way, it only goes from probable cause to malice in that situation. I think in terms of, you know, the issues that you take a look at in this case, you know, is there evidence of probable cause? Absolutely. We identified the absence of probable cause. We identified the failure to look at available evidence. Linda McMaster had the ability with phone numbers and identity of people to do a reasonable inquiry, and advice of counsel requires turning over all information plus what you could reasonably ascertain or reasonably obtain. She didn't do anything. And again, Kevin didn't do anything. Kevin McMaster didn't do anything the morning that he was at I-135. He did no investigation. When he is told, no, we're not going to give you access to the car because we don't know who you are. There's a procedure. And he thought, I don't want to know your procedure. Give me access to the car.
Is there any evidence that she asked him to file a lawsuit on her behalf?
None. In fact, quite to the contrary, she testified in her deposition, and we point this out, she had no idea that a lawsuit was being filed. Linda McMaster had no idea it was being filed. She found out later.
So I guess you infer malice on her part because of malice done by Kevin. Is Kevin's malicious intent is then inferred to her?
Well, keep in mind too, that you can also get malice with continuing the lawsuit. So when the lawsuit continues and she's aware of it, then there can be malice, lack of probable cause and malice. So I think in that situation, given that Linda was unaware that it was filed initially, she can be held liable and finding made against her based on the continuation and failure to stop the action at that point. You know, in addition, you know, Kevin goes back to his office that morning and drafts a lawsuit and files it that afternoon. No investigation. I asked questions and we made findings in our brief about lack of effort to find facts, lack of effort to check. He didn't check with the guy who did the repossession. He had a phone number for the guy. He did not ask who that person worked for. He did not make the most basic inquiry that you would make to try to figure out what was going on, who should be sued, who needed to be held accountable, and what actions were wrong. District court judge in this case made a finding that the actions of my client were reasonable given Kevin's conduct that morning. Kevin's conduct smacked of, don't you know who I am? how can you dare not do what I demand? Well, it's easy. And the judge found in the underlying lawsuit, the conduct of my client as an independent basis for a ruling against Linda McMaster was that the conduct of Kevin was unreasonable that morning in making those demands.
Let me ask you a question. If you were, as you do now, represent I-135 auto auction, and if you were there and that clerk turned to you and say, should I give this man access to the car? What legal advice would you have given that clerk?
I would have told her absolutely not,
Why?
because it's not his car. The person who gets access to the car is the owner of the car, or,
He couldn't describe the car other than the color.
correct.
Did he mention what he wanted out of the car?
As far as I can tell from the testimony, probably not. He wanted personal property out of the car. Well, I mean,
Did he identify himself? Did he say he was the owner of the car? Any of all of that?
I believe he had a business card. I don't believe he provided any type of photo ID like a driver's license.
So your legal advice to that clerk at that time would have been,
Two people are entitled to access to the vehicle. One is the owner of the vehicle, the other is the entity that put the vehicle in my possession.
that would be Speedy Cash.
Yeah. That would be the best advice I would provide in that situation. And clearly, I mean, it just makes common sense. A person comes into a location where there are hundreds of cars and saying, I want access to that green car over there. Is it your car? No. Well, then no, you're not getting access to it. We don't have any idea why you want access. We don't have any idea whether you're authorized to have access. And the person who put it in our possession hasn't authorized this, so no, it's not happening.
Technically, what, the car is an availment situation, you're bailee,
Correct.
and Speedy Cash is the bailor.
Correct. It wasn't the owner of the car, it was Speedy Cash. Speedy Cash took possession of it. And again, if there's some complaint about the way in which it was done, with personal property in the vehicle being taken in the repossession, that had nothing to do with my client. That had to do with Speedy Cash. But for some reason, Speedy Cash skated clean on this and they didn't get sued. Even though they were well aware, they being the McMasters were well aware, either at filing or shortly thereafter, that Speedy Cash was the entity that did the repossession.
But the McMasters had no business dealings with Speedy Cash, did they?
None. And we had testimony at trial from a representative of Speedy Cash who talked about the agreement to loan money and taking a secured interest in the vehicle, and there was a default in a repossession, self-help repo. All of that had nothing to do with my client.
We're over your 15 minutes. Is there anything you'd like to say just to wrap up?
There's no more questions? No. I think at this point, Your Honor, the decisions, Your Honors, the decision of the district court of the jury should be affirmed. And across appeal is protective only.
Thank you.
Thank you.
Mr. McMaster, since Mr. Schultz graciously yielded you a minute of his time, it sounds like Congress or something. You have 3 minutes for rebuttal.
Unfortunately, I think many facts are getting confused, and I'm going to run through them quickly. First of all, opposing counsel has claimed there is no evidence of advice given between attorney and client. Undisputed evidence at trial was that she would occasionally inquire and I advise her the status of the case, turning a case over to an attorney to handle his advice of counsel. You don't have to seek advice for every movement, this, that, or the other thing. Asking them to pursue the best remedy is appropriate. That's advice of counsel. Next,
Did you ask her to file on her behalf, or did you just do it automatically?
well, because of the directions I was given that morning when I went to the office, I understood the only way I was going to get things handled quickly before we had to worry about somebody getting access to our home was to file an action. So I did that and I advised her of the action later that evening.
Fait accompli.
Right. The claim that they were never in possession, auto auction was never in possession of the garage door opener. It was admitted in the underlying action. It was confused at the trial of the underlying action, and it was determined at the trial that clearly auto auction knew they were in possession. Speedy Cash knew they were in possession of our garage door opener the day the car came in. That's undisputed, and it was sort of hidden from us. Number two, auto auction saying they have nothing to do with the repossession of the vehicle is a fallacy. It is legally wrong, and I can't understand how that argument's made. You repossess a vehicle, self-help. You don't just take it. You take it, you get a repossession title, you sell it, and you dispose of the property and disperse the proceeds according to the law. There was a contract between Speedy Cash and auto auction that said they'd store the vehicles, they'd get a repo title, they'd inventory and clean them out, they'd sell them, and they'd dispose or give title in the vehicle to the buyer and then distribute the money. That's part of the repossession process, period. They're not a mere bailey where they're just storing something. They can't claim ignorance. They agreed to clean inventory, etc. The next point about the judgment being satisfied, no, this appeal couldn't go forward if it's satisfied. I mean, there is a judgment, yes, but it hasn't officially been satisfied. The key here is that there was a conversion of personal property. There are various ways that you can recover damages and or personal property. A very minor, inconsequential, less burdensome way of filing a limited action, making a prayer for the smallest amount that you can to get things taken care of. And if you look at this big blow up, it all had to do with auto auction comes in and starts doing such thing as filing third-party petitions, doing erroneous discovery, filing motions, doing this. This is a case that got blown out of proportion only after it had been filed, served, and the property returned. With regards to wholly recovering, there isn't an issue about a whole recovery of us having to prove that, oh, gee, because of the suit they did it. It's the suit happened, the suit was served, the property was returned, but that didn't mean there weren't still damages. Maybe nominal, but still damages. What if an auto auction personnel had taken the garage door opener and robbed the house the next day or so? The filing the action would and should be perceived the exact same way.
You're at about 4 minutes now, so you might want to wrap it up.
I thank you very much for your time, unless you have any questions. The key here, from the very beginning, summary judgment should have been granted. Summary judgment wasn't. Motion for judgment as a matter of law should have been granted because there was probable cause and the recovery or the results of the underlying action weren't wholly in favor of auto auction. Thank you.
Thank you all. And again, we'll take this case under advisement and get an opinion out to you as quickly as we can. And with that, we are adjourned. Thank you, guys.